Hey, this is Brian Stone, a practicing attorney here in New Hampshire with a background in criminal and family law. You're listening to Law Talk NH Unfiltered, where I break down legal topics in plain English to help you better understand your rights in the legal system. In this episode of Law Talk NH Unfiltered, I take a step back and talk about what happens before someone is officially under arrest in New Hampshire. Many people don't realize there are different types of encounters with police. Some where you're free to leave, and others where you're not. Even if no one says the word arrest, I'll break down what those interactions look like and what your rights are at each stage. We'll talk about on the street interactions, what the law calls temporary seizures or Terry stops, and how to tell whether you're free to leave or being legally detained. Understanding these distinctions can make a big difference in how you respond and protect your rights. Not every time a cop talks to you does the law say you've been seized or stopped. The Constitution protects you from unreasonable seizures, but those protections only kick in when the police actually stop or detain you, not just when they say hello or ask some questions. Think of it like this. If a stranger on the street comes up to you and starts a conversation or asks to see your ID, you don't have to talk to them or show anything, right? Police officers have the same right to approach and talk to you without forcing you to respond or comply, at least until they make it clear you're not free to leave. For example, if you're walking down Main Street and a police officer asks if you're willing to answer some questions or to see your ID, you can say yes or no. The key is whether the officer makes it clear you have to comply or that you're being detained. If they don't, then legally you're still free to walk away, just like if it were any other person on the street. So just remember, not every interaction with police is an arrest or even a stop. There's a big difference, and knowing that difference helps you understand your rights and what you can do in those moments. If you're other, if you're ever unsure whether you're actually being detained by an officer or just having a casual conversation, it's totally okay to just ask, am I free to go? Am I being detained? If the officer says you're not being detained, then you're free to walk away and end the encounter. You don't have to explain yourself. You don't have to give your name or say where you're headed, and the police can't arrest you just for refusing to answer. That would violate your constitutional rights. Now, let's be real. Some officers might not like being challenged like that. And if they're determined to escalate things, they might start fishing for another reason to justify a search or an arrest. That's why it's important to be calm, polite, and clear. If you're going to assert your rights, do it respectfully and don't give them anything extra to work with. And remember, exercising your rights isn't the same as resisting. You're not required to answer casual questions, but don't physically walk away or argue unless you've confirmed that you're free to go. If the stop wasn't valid or they push it too far, your lawyer can challenge all that later in court. Now, a detention means the officer has to have what's called reasonable articulable suspicion. Basically, they must have specific facts or evidence that make them reasonably believe that you've committed, are committing, or are about to commit a crime. In some cases, an officer might have probable cause, which is even stronger standard, meaning they have enough facts to believe a crime probably happened, and you're probably going to end up going to the station in handcuffs under arrest. Let's talk about what's known as an investigative stop, or what you might hear called as a Terry stop, named after a famous U.S. Supreme Court case. This is basically a brief detention where the police officer stops someone because they have reasonable and articulable suspicion that the person is involved in criminal activity. It's not the same as an arrest. It's shorter. It's supposed to be less invasive and meant to give the officer just enough time to figure out whether there's actually something illegal going on or not. The idea is that the officer has noticed something specific and can explain why they think you might be doing something wrong, but they're still in the stage of confirming or ruling out their suspicion. So if the officer has a suspicion that turns out to be unfounded, the stop should end quickly and you should be allowed to go on your way. Now, here's something really important to understand about these investigative stops. An officer can't just go on a hunch. It's not enough for them to have a vague feeling that something sketchy is going on. That doesn't cut it legally. To justify stopping you, the officer has to be able to point to specific facts, something they saw or heard that made them reasonably suspect you were involved in some kind of wrongdoing. And not just any suspicion. It has to be based on logical, reasonable inferences drawn from those facts. There has to be a real, identifiable reason behind the stop, not just a gut feeling or something based on a stereotype. So if an officer says, "You look suspicious," that's not enough. They need to explain why. Like maybe they saw you matching the description of someone just involved in a nearby theft, or they witnessed behavior that clearly pointed to a possible sense of illegal activity. The key is that it must be specific and explainable, not just a guess. If you ever end up challenging the reason why you were stopped, what's called the factual basis for the stop, courts won't just take the officer's word for it. They'll look at all the facts the officer can articulate to decide if there really was reasonable suspicion to stop you. That's why officers are trained to document everything in their reports, what they saw, what you were doing, and anything else that led them to believe you might be breaking the law. It's that documentation that matters in court. Now, here's the practical advice. You might feel like the stop wasn't justified, and maybe you're right, but arguing that on the street with the officer probably isn't going to get you anywhere, and it could make the situation worse. If the officer refuses to let you go and insists they have a reason to stop you, your best move is to stay calm, comply within your rights, challenge it later in court. That's where the legal arguments belong, not on the sidewalk. Here's something important to keep in mind. If the initial stop wasn't legal, then everything that happens after that, what you say, what they find, what you do, could be considered what's called fruit of the poisonous tree. That's a legal term that basically means if the stop itself violated your rights, then anything that came from it might be suppressed or thrown out in court. So if the officer didn't have reasonable articulable suspicion to stop you in the first place, it might not matter what else they uncover afterwards. None of it may be usable as evidence in court at all. There are exceptions, of course. For example, if the police later develop a separate lawful basis to detain or search you, or if the evidence would have been discovered independently in some other way, that could change things. But if the only reason they found something was because of a bad stop, that's a problem for the prosecution, not you. This is why defense lawyers always look at the very beginning of an encounter. If the stop wasn't justified, there's a good chance the whole case could fall apart. Let's talk about something that often happens during these street encounters, the pat down or frisk. If an officer has stopped you and they have a reasonable belief that you might be armed and dangerous, they're allowed to do a limited search of your outer clothing. This is what's called a protective frisk. It's not meant to look for drugs or other evidence. The only purpose is to make sure you're not carrying a weapon that could pose a threat to the officer's safety. But here's the key. This kind of search is supposed to be strictly limited. If the officer doesn't feel anything that obviously seems like a weapon, they're not supposed to go digging around in your pockets or reaching inside bags. So, unless something during the outer pat down makes them reasonably suspect there's a weapon or something illegal, reaching inside your pockets would likely go beyond what's allowed, and any evidence they find that way could be suppressed in court. This is another situation where it's smart not to argue your rights on the street. Stay calm, and if the officer crosses the line, your lawyer can fight that later in court. If the officer says you're being detained, then you're not free to leave until the officer finishes their investigation. But even then, this detention can't last forever. It has to be only as long as necessary to confirm or rule out the suspicion. For example, being stopped on a sidewalk because someone thinks you stole a bag of chips shouldn't result in a 12-hour detention. This idea comes from the law about when a person is considered seized by the police, which means they're not free to leave. Basically, if you look at the situation and ask yourself, would a reasonable person in my shoes feel like they could just walk away? If the answer is no, then legally you've been seized. When it comes to whether you've been seized by the police, it's not just about physical contact or having a gun pointed at you. Instead, the courts look at what's called the totality of the circumstances. That means everything happening around you during the encounter. For example, New Hampshire courts take a pretty broad view on this. A seizure can happen even if the officer doesn't touch you or show a weapon, as long as the words or actions of the officer make it clear you're not free to leave. There is a case where a man was walking alone on a quiet street at 1 in the morning. The police called out, "Hey, you stop." When he didn't respond, they said, "Hey, I want to speak to you." The court said that given the time of night, the quiet street, the tone of the officers, no reasonable person would have felt free to just ignore the police and walk away. That meant the man was legally seized and entitled to constitutional protections. So when thinking about whether you're seized, it's not just about what the officer does physically. It's about the whole situation and how a reasonable person would feel in your shoes. Now, here's something interesting about New Hampshire law. It's a bit different from the US Supreme Court and some other states. In New Hampshire, you don't actually have to submit to the police or be physically stopped for a seizure to occur. What matters is whether a reasonable person would feel like they weren't free to walk away because of what the officer did or said. So, even if you decide to run from the police after they tell you to stop, you could still be considered legally, quote, seized, unquote. Basically, it's about how the situation feels from a reasonable person's point of view, not whether you actually obeyed or stayed put. That means the police have, in effect, stopped you in a way that triggers your constitutional rights against unreasonable searches and seizures. So it's not just about what the officer says, but how the whole encounter feels from the average person's perspective. If it feels like you can't leave, that's when the law says you're officially seized. When you're detained, the officer may ask you for your identification. But here's an important fact. You are not legally required to identify yourself or show ID unless the officer has probable cause, in which case you will have been placed under arrest, most likely. Sometimes officers can be stern or even say you have to, trying to convince you it's mandatory. But legally, it isn't, at least not outside of certain situations like driving, which we'll cover in another episode. However, in general, if you don't have any warrants, it's usually best to just identify yourself. Even if you are detained, you're not required to answer questions or engage in a conversation with the officer at all. If the officer says they have probable cause, that means they have enough evidence to arrest you right then. In that situation, you should definitely identify yourself, but be careful about talking about the incident without a lawyer present. Anything you say will probably most certainly be used against you. And this includes anything you said prior to your arrest and before even being detained. This is why lawyers always say to keep your mouth shut. To explain a bit more, probable cause means the officers have facts and circumstances that would lead a reasonable person to believe that a crime has been committed or is being committed. That means that once the officer is done fishing for whatever he can get out of you, you're going to be placed under formal arrest. That means in handcuffs, off to the station, or off to jail. Remember, all this talk about identifying yourself applies differently if you're driving a vehicle. The rules are different for drivers, and we'll dive into that in the next episode.